Hey all, I'm the Indie Lawyer and welcome to another installment of Lawvel 101. Because things are a bit strange right now, we're going to deviate from our schedule slightly. But hey, intellectual property is getting boring. I thought it'd be useful to talk about the legal implications of a pandemic when you're running a studio. I'm going to split this into two small videos to get them out quicker, but the first thing we're going to look at is what happens when a pandemic causes you to breach a contract and a concept called force majeure. The second video is going to take a quick look at the schemes that have been introduced in the UK to protect your business and your employees. So, first things first, let's talk about acts of God. Game studios enter into legal agreements with a lot of people. A few notable ones might include your publishers, your landlords for the offices that you rent, and various freelancers if you commission assets outside of your studio. Now, normally if you enter into a contract with someone to do something, if you don't do that thing, you're in breach of contract. If you paid me to make a game, for example, by the 30th of April and I didn't, you could sue me for the damages you've lost as a result of that. Maybe you agreed with a platform that you were going to publish that game onto that platform by a certain date, but because of my breach, you're now paying fees to that platform without actually having a game to publish on it. You may also choose to terminate the contract completely and ask me for a refund of any fees you've already paid to me. But what happens if something's happened that's outside of my control that means I had a good reason for not complying with my obligations and the date you set in the contract? Maybe because of the virus, my studio is disrupted to the extent that we can't develop your game. Well, then there's scope for changing the goalposts. The first reason for this is a legal concept that crops up in a lot of contracts: force majeure. A force majeure clause is usually found towards the end of a contract. Now, very basically, it excuses one or both parties from their obligations under a contract when a certain event occurs, usually one that's outside of one or both of the parties' control. It's something we stole from the French legal system, so unless it's actually in your contract, it doesn't apply. It's a clause that 99% of the time no one cares about, but in times like this it becomes very, very important. Before we jump into it, I just want to make it clear that force majeure isn't an easy get out. It's usually linked to significant disruptions like floods, political unrest, or terrorism, not just an event that makes it inconvenient for you to comply with your obligation. Now, for force majeure to kick in, you need to check two things: whether the virus is covered by the wording of a clause, and if it is, whether you're prevented from carrying out your obligations under the contract because of that. So is COVID-19 likely to be a force majeure event? It's a question I've been asked a lot lately, and the answer is it depends, as always with lawyers. Firstly, you need to check whether a pandemic, crisis, or government order is actually mentioned in the clause specifically. If so, then COVID-19 is likely to be covered because the disruption is caused by either the virus itself or an order of the government, for example, directing your staff to work at home or for your studio to close. If it doesn't specifically mention it, it might be more vague, suggesting that a force majeure event is simply an event that's outside of a party's control. If so, then whether COVID is covered depends on the wording of the contract, although during these weird times we expect that the courts will interpret this very generously. Now, I'm provisionally taking the view that due to the global disruption being caused, most force majeure clauses will include COVID-19, but ultimately this will differ from contract to contract. So if it is covered, you then have to prove that you've been prevented from carrying out your obligations. Again, this isn't straightforward. Depending on what your contract says, you'll need to show that performance is legally or physically impossible because of COVID-19. It can't just make it difficult or unprofitable, and you must be able to show that you've taken reasonable steps to avoid or mitigate the event and its effect on your contractual performance. For example, if you're a freelancer engaged to create some art for a studio and you could work from home to make the content, you're less likely to be able to show that you've been prevented from carrying out your obligations under the contract. If these two boxes are ticked, then there's scope to argue that the force majeure clause kicks in and your contractual obligations can be extended, suspended, or the agreement could just be terminated in general. It depends on what your clause says exactly. Now, if your clause doesn't include a force majeure clause, it's not ideal, but it's not the end of the world. You might be able to fall back on the concept of frustration. Frustration is a similar concept to force majeure, but is generally a much harder hurdle to overcome and kicks in when a change of circumstances outside of the party's control makes the performance of a contract very different from what was originally agreed. And when frustration occurs, both parties are excused from further performance and are generally not liable for any breaches. Unlike force majeure, it's a permanent thing. If there's frustration, the contract is torn up and it ends. Again, like force majeure, just because an event makes something more difficult or expensive to do doesn't mean that frustration has necessarily happened. In England and Wales, our law prevents the recovery of any money paid under a contract before it was discharged by frustration, so it's less desirable than using a force majeure clause. That was very briefly contracts during COVID-19. If you feel you need to suspend or extend any contracts, you need to carefully check whether you have the legal power to do so, and ideally consult a lawyer. Doesn't need to be me, just someone. As everyone's in the same boat, often the first bet is to reach out to your contractual partners and see if there's an agreement that can be reached before taking sort of any drastic legal steps like suspending payments. If you've got any queries about your contracts, feel free to get in touch and tune in for the next instalment when we'll be looking at some of the government initiatives in the UK to assist creative businesses like video game studios. Stay safe, catch you later.